Good morning, everyone, and welcome to today's webinar. For those of you who have just logged on, we have already completed a sound test, and thank you very much to everyone who helped out with that. Firstly, I want to introduce myself. My name is Jennifer Patton, and I'm the HR consultant for Bright Contracts here at Bright. This webinar is being recorded and all attendees will receive an email later today with a link to the recording, so it's no problem if you do need to leave at any stage. If you do have any questions, you can type them into the questions box on your control panel at the side of the screen, and we will try to get through as many questions as possible. Also, in the follow-up email, there will be a copy of the presentation slides that we are using today. So we'll just briefly go through the agenda. So first up on the agenda for today, we will look at the topic everyone has been wondering about, which is Statutory Sick Pay or SSP and what it means for our employers. The second topic then is the payment of wages bill. From there, we'll move on to parents' leave, gender pay gap reporting. And the last two topics will be the Directive on Transparent and Predictable Working Conditions and the Protected Disclosures Amendment Act 2022. As I previously mentioned, at the end of the webinar, we will have a questions and answers section where we'll answer any questions that you may have on any of the above topics. So let's move on to our first topic, which is statutory sick pay. So firstly, what is SSP? So SSP stands for Statutory Sick Pay, which is a legal right for employees to be paid by their employer when they are absent from work due to illness. Now, obviously, we know in the past employees previously had no legal right to sick pay, but the introduction of the Sick Leave Act 2022 has made this become law, and it was signed in last month by the President, and it's due to be enacted early this month. Now, there are a few specifications in order to be entitled to be paid sick leave, which under the scheme include that an employee must have 13 weeks of continuous service with their employer, and those who are eligible for the scheme will be required to produce a medical certificate in respect of each day of statutory sick leave. Now, employees who require further time off after their entitlement to sick pay from the employer, they may be eligible for illness benefits from the Department of Social Protection, or DSP as it's commonly known, but this will be based on subject to their PRSI contribution, so it will depend on every individual circumstance. So what will the SSP scheme introduce? So it will introduce 3 days of paid sick leave this year, and the Department of Enterprise, Trade and Employment has indicated that this will increase to 5 days in 2024, 7 days in 2025, and 10 days in 2026. Now, this phase rollout does take into account the current pressures on business in terms of rising costs and inflation, so there is a provision to vary by ministerial order the number of statutory sick days per year, but this will be in regard to, and these are just to name a few, there is a more extensive list than what I'm about to list, but they will be in regard to, for example, the state of the general economy, the state of society, the potential impact, and what I mean by that is the potential for any adverse impact that the making of the order may have on specific sectors, employers or employees, etc. So moving on to the payment side of the scheme, employers will be responsible for paying up to 70% of the employee's normal wages. And before anyone asks this question, because I've had this a few times, the government will not top this up to 100%. So it is the employer who's responsible for paying 70% of the normal wages. It will not be topped up. But it is subject to a daily maximum of €110. Now, the new scheme, it does operate as a minimum entitlement and it doesn't prevent employers from offering better sick pay provisions to their employees. So what if an employer cannot afford SSP? Now, the Act applies to all organisations, regardless of size or headcount. So if an employer cannot afford to discharge its SSP obligations, an exemption may be granted by the Labour Court. But if an employer already provides more favourable sick leave benefits to an employee, they won't be obliged to comply with the statutory sick pay rules. However, the employer will have to demonstrate that any discretionary or pre-existing scheme is more favourable than the one provided for in the legislation. So what do you as the employer need to do? So employers must review their existing sick pay policies to check whether these new SSP rules will affect or change them. The contract of employment should also clearly state the company's rule on sick leave. So it may limit the length of time you can get sick pay. So for example, 1 month sick pay in any 12-month period. It may state that if you are sick and unavailable for work, you must contact a specified person by a specific time. But if an employee does not get sick pay, although it is in their contract or terms of employment, employees can make a complaint under the Payment of Wages Act. And it will be mandatory that employers keep a record of any statutory sick leave taken by employees, and they must be retained by the employer for a period of 4 years, which is vitally important. Also, any failure to comply with this record keeping requirement may result in a fine of up to €2,500. So SSP and the WRC, where an employee believes that their employer has failed to comply with the provisions of the Act, an employee can make a complaint to the Workplace Relations Commission, the WRC as it's most commonly known. And if successful, an employee who makes such a complaint may be awarded up to 4 weeks remuneration. Now, however, the Act does provide exemptions that can be granted where the employer is experiencing severe financial difficulty. So it will be mandatory that the employer keeps a record of any of the sick leave taken if this instance were to arise and they were to find themselves in the WRC. This is exactly why having your records going back for a period of 4 years is so vitally important. So what exactly is going to happen next? So while it's signed into law, the provisions of the Act has yet to come fully into force. As I previously mentioned, it has obviously been signed in by the President, and we have all been informed that the official enactment date is early this month. So we're still waiting for that official date, but hopefully it will come in the next few days or weeks. So how has Bright Contracts gone about making a change? So we have actually already just recently updated the Bright Contracts section. The contract section of Bright Contracts. So as you can see from the image here, the little note, or as we call it, the helpful toolbox, this is where we give guidance or notes throughout the contract section for you as the employer to get an idea as to what information to populate in any of the free text boxes there. So as you can see, we've put in subtext there for you. But we have also updated the handbook on a small scale under the absence and annual leave section. We haven't detailed too much about it in the handbook because, as I previously mentioned, your contract of employment should detail your sick pay arrangements. So this is where we find what we have in the toolbox may be helpful to have that in the contract, and then also the small addition to the handbook. But when you log into your software, just simply go to the absence and annual leave section of the handbook, and then in the contract section, go to where you detail your sick pay arrangements. Now that we've discussed SSP at length, we're going to move on to the Payment of Wages Bill, which is also known as the Tips and Gratuities Bill. So in addition to passing the sick leave bill, the Oireachtas also passed new legislation to ensure that those working in the hospitality industry receive their fair share of tips and gratuities. The aim of the bill is to provide clarity on the meaning of tips, gratuities and service charges, to place tips and gratuities but not service charges outside the scope of a person's contractual wages, to oblige employers to display prominently their policy on the distribution of both cash and card tips, And lastly, to oblige employers to distribute fairly and in a transparent manner the tips that are received in electronic form. So that's whether it's through debit or credit cards or even smartphones. Where an employer fails to adhere to the specific obligations under the Act, they are liable under summary conviction to a Class C fine of a maximum of €2,500 fine. So, what steps should employers take? There will be new requirements on employers to clearly display their policy on both how card and cash tips, gratuities, and service charges are distributed, so to ensure that they are in line with these new changes in the law. So that was just a small change to that bill. And now we're going to move on to parents' leave, which also had a change. So as we all know, parents' leave was extended during the pandemic. And now, as of July of this year, parents can now avail of 7 weeks paid parents' leave and benefit as part of measures introduced by Ministers Heather Humphreys and Roderick O'Gorman. So the support applies to both parents and is part of the government's initiative to ensure that parents can enjoy meaningful and quality time with their newborn in the knowledge that they'll be financially supported, which obviously, given the current climate, is vitally important. Parents' leave and benefit is available to anyone with a child under 2 years of age or who has adopted a child within the last 2 years. Now, Minister Humphreys and Minister O'Gorman have stated that they are committed to a further expansion of parents' leave. So they're hoping to extend it to 9 weeks in line with the Work-Life Balance Directive. So if this should come into enactment anytime soon, we will obviously keep you informed. So parents' benefit is available to both the employed and self-employed parents with the required number of social insurance, so PRSI contributions. And as I previously stated, it's available to parents within 2 years of the child's birth or adoption. Parents' benefit is still paid at a rate of €250 a week, which is the same rate as maternity, paternity, and adoptive benefit. Again, it is 7 weeks payment, and this is for each parent, representing a payment of €1,750 per parent. Now, the Parents' Benefit Scheme is family friendly and flexible, and facilitating parents can avail of the 7 weeks in a consecutive block, or they can do it in separate weekly blocks over a longer period. It will be based on the individual. The quickest way and easiest way for them to apply for parents' benefit is online via mywelfare.ie. We have recently changed the leave and benefits section of our company handbook to reflect this increase in parents' leave, so that can be viewed in our software. So before we dive into the specifics of the gender pay gap reporting, I think it is important to note the difference between the mean pay gap and the median pay gap. So I'm going to go into discussing that firstly. So the mean gender pay gap is the difference between men and women's mean hourly wage, and the mean hourly wage is the average hourly wage across the entire organisation. Whereas the median gender pay gap is the difference between the women's median hourly wage, so the middle paid woman, and the men's median hourly wage, so the middle paid man. And the median hourly wage is calculated by ranking all employees from the highest paid to the lowest paid and taking the hourly wage of the person in the middle. So now that we've distinguished the difference between those, we're going to move on to the Gender Pay Gap Information Act, which was signed into law on the 13th of July 2021. So the Act amends the Employment Equality Acts 1998 to 2015 in the form of the Employment Equality Act 1998. The regulations have placed reporting and publication obligations on both the private and public sector employers. Now, it does only apply to employers with 250 or more employees for the first 2 years after their introduction. And in the third year, the regulations will also apply to employers with 150 or more employees. After 3 years, the regulations will apply to employers with 50 or more employees. The regulations will not apply to employers with fewer than 50 employees. Now, the Minister has indicated that a central website where employers will be required to upload their information will be established in 2023, but for reporting in 2022, employers are only obliged to report on their website or at least make it available for inspection during normal business hours. So the reporting requirements, now I'm not going to go into each of these individually as there is a lot, but I just wanted to list for you all what the reporting requirements are. So as I mentioned previously, for example, the mean hourly remuneration gap, the mean bonus remuneration gap. Then we also have the percentage of male employees who were paid bonuses and the percentage of female employees who were paid a bonus, etc. So you can look through those at a later stage. So how can you get your data ready? So firstly, you will need to involve your company's key stakeholders. And in order to calculate and explain your gender pay gap, you'll need support from across the organisation. So make sure you engage with other departments early on to facilitate with this. The next step then is to collate and review your data in line with the requirements. So this will provide you with a snapshot of the current gender pay gap in your organisation. From there then, you'll need to understand your pay gap and understanding the reasons for your gender pay gap. And you need to do that as early as possible, as it gives you time to work out how to explain them, if the reasons are fair and valid, or to seek professional advice on how to address them and to take action before you publish your first gender pay gap report. The next step then will be to plan your communication strategy. So your organisation will need to own the narrative around your report and prepare for any challenges to your report from third parties. And then lastly, you'll have to look at how you respond when you identify a gender pay gap, as it could come under as much scrutiny as your gender pay gap itself. Therefore, failing to demonstrate positive change could put you at a disadvantage. So it's really important to think about how changing policies and practices in key areas such as recruitment, training, retention, etc. can help to reduce your gender pay gap. Now let's move on to the EU Directive on Transparent and Predictable Working Conditions. So this directive aims at improving working conditions by promoting more transparent and predictable employment while also ensuring labour market adaptability. Many of the requirements of the new directive are already provided for in existing Irish legislation, which is namely the Terms of Employment Acts 1994 to 2014 and also the Employment Act 2018. However, the list of information employers must provide to workers has been extended, as well as certain notification obligations being expanded. And I'm just going to go through some of the main important ones. So for example, employers will be obliged to provide employees no later than 7 days after their start date with the following in writing. So firstly, their start date and not just the duration of the contract, details and duration of the probationary period, the place of work, or where there is no main place of work, a statement indicating that an employee is required or permitted to work at various locations. And lastly, the title, grade, nature or category of the work, or a brief description of the work. In relation to predictable working patterns then, the employers must provide the length of the standard working day or week, as well as any details in relation to overtime and shift changes. In relation to unpredictable working patterns, then, it must be detailed the number of guaranteed paid hours per week, the remuneration for hours worked in excess of the guaranteed hours, the hours or days within which the worker may be required to work, and the minimum amount of advance notice provided to employees about working hours. Next, we move on to provision of probationary periods exceeding 6 months. So there will be a prohibition on probationary periods exceeding the 6-month period unless it is on an exceptional basis. And this is justified by the nature of the employment or the employee's interest. So absence during the probationary period will justify an extension of equivalent duration, and any probation periods in fixed term contracts, they need to be proportionate to the overall duration. And furthermore, the directive does stipulate that a probationary period will be prohibited in the event of a fixed term contract renewal. Then we move on to the right to request a transition to more predictable and a secure position. So workers with at least 6 months service with the same employer and they've completed their probationary period, they will have a right to request to transition to a more predictable and secure position, provided that an opportunity is available. Now, where an employer declines this request, the employer has to provide detailed written reasons, and generally this will be within 1 month of the request, and it must explain the rationale behind the decision. Next, then, we move on to the employer paying for mandatory training. Now, where mandatory training is prescribed under EU law, national legislation, or collective agreements, the employer must pay for that training, and it must count as working time, and where possible, it must take place during working hours. And the directive does introduce a new requirement that the employer, no later than 1 month of the start date of employment, has to provide the employee with their mandatory training entitlements in writing. Next, we move on to variation in terms of employment. So any variations to the terms of employment must be notified to the employee at the earliest opportunity and at the latest on the day on which the change takes effect. So what does an employer need to do in relation to this directive? So it's really important to note that these additional obligations around the provision of information, around the terms and conditions of employment, they don't actually need to be provided by the employer to existing employees unless it's requested by that employee. But it doesn't exclude the employee from the minimum rights established in relation to probationary periods, parallel employment, etc. So employers should review and amend, if necessary, any template contracts of employment or policies which they issue to new employees from the 1st of August 2022 onwards. And this is to ensure that all policies, contractual terms, and the provision of information reflects the new obligations as of that date. And lastly, we come to our final topic, which is the Protected Disclosures Act 2022. So this act introduces a new obligation to have a whistleblowing procedure and significant detail on the content of the procedures. And this is going to apply to all public sector employers. Public sector employers were already obliged to have a whistleblowing procedure, but that obligation has been amended significantly now due to this act. It also applies to any employer with 250 or more employees, and this is from the date of commencement of the Act. It also applies to any employer with 50 or more employees, and this is from the 17th of December 2023. And all employers who fall within the scope of certain EU law provisions, and this is referred to in the directive, and this is from the date of commencement of the Act. So, for example, this will apply to most employers in the area of financial services. Any employer that is required to have a procedure in place, they will also be required to appoint a designated person to receive and follow up on disclosures, and this is really crucial role under the Act. This Act also amends the definition of relative wrongdoing in a number of ways. And the definition of relevant wrongdoing includes the following: so that an offence has been or is likely to be committed, that a person has failed, is failing, or is likely to fail with a legal obligation. So this is other than one arising from a contract of employment. And lastly, that the health or safety of any individual has been, is being, or is likely to be endangered. Now, the Act does specifically exclude workplace grievances from this definition of relevant wrongdoing. But the bill, it does expand on the definition of relevant wrongdoings to include breaches of EU law in a number of areas, and I'm not going to list them all, but to give you an insight into a few, some of the areas would be public procurement, financial services, product safety and compliance, transport safety, protection of the environment, etc. And the amendment does also provide that if any employee makes a claim of penalisation to the Workplace Relations Commission on any of the above actions, it is deemed to have been a result of them having made a protected disclosure, unless the employer proves that the act or omission was based on duly justified grounds. Now, it does also detail that instead of the information being required to having come to the worker's attention in connection with their employment, it can now also come to their attention in a work-related context. So that is vitally important to take, that this amendment has widened the scope, so to speak. So what are the key steps for employers in relation to this Act? So firstly, you need to ensure you have an appropriate whistleblowing procedure in place. Procedures are a legal requirement for certain employers, and it is a good practice requirement for all. You must also have a well-drafted procedure which ensures employees have an internal reporting channel, and this also reduces the risk of a disclosure to other bodies outside of the employer. Procedures may also reduce the risk of successful legal claims as well, and any existing whistleblowing procedures should be reviewed against the detailed provisions of the Act. You should also confirm if you are an employer to whom these additional obligations concerning procedures in the Act applies to. And if the Act applies to you, your procedures should mirror the requirements of the Act, and you should appoint a designated person, as I mentioned previously, who is appropriately trained to deal with these disclosures. You must also deal appropriately with any whistleblowing disclosure. So you should ensure that the whistleblower is never penalised for raising a legitimate concern, and that any concern is assessed or investigated in the appropriate manner. Now, in the public sector, your whistleblowing procedures will need to be amended to comply with the Act, and a designated person, or you might have persons appointed. You will also need to make sure that they are aware of the more detailed reporting obligations contained in the Act as well. So that brings us to the end of our webinar. I know it was a lot of information to take in, and I hope all of you are still with me, but I hope you also found it very informative. But before we get to the Q&A section, I would just like to mention that if you'd like to sign up to get a demo of the software or sign up to receive the newsletter, then you can either email us directly, or at the end of the webinar, we do have an after webinar survey where you can register your interest for those also. It is now time for the questions and answers, and if you have any questions, feel free to type them into the questions box. I know a lot have come in as I've been going through the webinar, and I will try to get through as many questions as possible. I just want to let you know I will have some extra documents available in the follow-up email just to help you with your knowledge of these topics that I've gone through, as they can be tricky to get your head around, to get all the key points. So I hope you'll also find those extra documents useful. Now, we do have a lot of attendees logged on today, and I am conscious of time. So unfortunately, I probably won't get a chance to answer every single question, but I will do my best. And those that I don't get to answer, I will revert back to them by email. So I'm just going to start off here with some SSP questions. So what is the SSP for part-time employees? Okay, so both full and part-time employees can avail of paid leave under the scheme as long as they meet the criteria of the 13-week service and that the sick day falls on a day that they would usually work on. What happens if an employee requires further time off? So again, as I said, the employee may qualify for illness benefit from the DSP, but this will be based on their PRSI contributions. What steps can organisations take to reduce the gender pay gap? So efforts to close the gender pay gap, they are long term. So organisations must use the information gathered from their gender pay gap report to guide and shape their action plans. So for example, if an organisation has a large gender imbalance that is in favour of men at the management level, measures to understand why this is happening and how to address it, they need to be put in place. How is statutory sick pay calculated? So as previously mentioned, the payment will be 70% of gross normal earnings and up to a maximum of €110 per day. And that applies from the first day of illness. So for those who aren't paid a fixed salary and their income varies in relation to their work done, their normal earnings will be calculated over a 4-week period prior to the sick leave. Or if no time was worked in that 4 weeks, then the 4 weeks ending on the day in which time was last worked is used. And the cap was set to help employers to manage costs and to make the scheme more affordable. So particularly owners of small businesses and those operating in sectors like retail and hospitality, where they need to pay for temporary staff to cover absences. So they are the ones who will really benefit from the cap. Does temporary layoff affect the entitlement to SSP? Now, it doesn't. However, it does depend on individual circumstance. So, for example, childcare workers who don't work over the summer, they're still eligible for sick leave, but only if they've accumulated at least 13 weeks service before the end of term. And the last question that I have time to answer again is in relation to SSP, and it's, can SSP be backdated? And the simple answer there is no, it cannot be. Now, I'm afraid that's all the time that I have to answer any of the questions. As I previously said, if any of your questions weren't answered by me today, I will get a report of them at the end and I'll get back to you individually. But if you have any other questions, you can contact us at the email address or the phone number provided, and a member of our team will be happy to assist you with your queries. But thank you so much for attending, and I hope you found it useful, and I hope to see you all again at our future webinars. Thank you very much.